Please state your full names for the record.
Setlhomamaru Dintwe.
Do you have any objection to taking the prescribed oath?
No objection.
Do you consider the oath binding on your conscience?
I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated.
Thank you, Chair. Dr. Dintwe, your statement in affidavit form is before the Chair in bundle SSA 2B, and it's exhibit YY 15. We ended the last session of your evidence at page 812, the black numbers in the top left-hand corner of the pages.
I confirm that I can see that.
You gave evidence before we adjourned in relation to an appointment or the approval of appointment, you say, without due process by Mr. Bongani Bongo. And you deal with that in paragraphs 119, 120, and 121 of that page. You informed me just before commencement of your evidence today that there was an issue that you wish to clarify.
That's correct, Chair.
Please do so.
Yes, Honorable Chair, I am not amending what I would have written there, but I could have created an impression that the Minister accepted our findings and recommendations readily at first instance. But I've since checked my records again. There was some other correspondence that I would have omitted. And I think that the Commission and the Chair will appreciate that I'm sitting with about 200 complaints at any given time. So those mistakes do happen. But it does not really change the whole complexion of what I would have written in my affidavit. I, however, request your permission that I read something here so that I clarify that one step that I say that I would have jumped.
That's fine.
Thank you very much. And then I continue. So we've written to the Minister with the findings and recommendations, but she then wrote to us, and although she was not saying that the appointment was regular, she raised about 3 points, and we accepted them as inputs, because when you are doing investigation, you want to also give them an opportunity to input into that investigation. So we accepted that, but the following points were raised in her letter. And this was on the 27th of February 2020, where she said that from the report, it appears as though the former Minister of State Security, Mr. B. Bongo, and the former Director General of State Security Agency, SSA, Mr. A. Fraser, were not interviewed with the aim of ensuring that the other version is heard. It is difficult for me to reach a logical conclusion without information from these two critical role players on this matter. And then she further concluded in her letter, and I quote, open quotes, "It will be prudent to guard against a culture that erodes the integrity of the organization and opens up such issues once the political principal has left," close quotes. So the investigators then decided to explain those matters and the reasons, obviously, why we didn't. And the following reasons were sent to the Minister, and these are not direct quotations, but they will be in my report. In the, if you like, the report after the inclusion of her inputs. We said that there was no need for us to have interviewed the former Director General, Mr. A. Fraser, in light of the fact that Mr. Fraser, as the accounting officer of the SSA, then was excluded in the submission to appoint the aforesaid member to the position aforesaid. So you will have a number of signatories, and Mr. Fraser was not in fact, one of those signatories. The second reason that we provided was that we are in possession of the approved submission wherein the member consent was appointed to the aforesaid post of program manager within NICOC, the National Intelligence Coordinating Committee. The approved submission as an official document under the custody of the State Security Agency constitutes prima facie proof of the appointment of the said member by the then Minister Advocate Bongani Bongo MP, as contemplated in Section 8, Subsection 2 of the Intelligence Services Act 65 of 2002. The third reason, it was clear on the face of the submission aforesaid that the appointment of the member concerned by the then Minister of State Security, Advocate Bongani Bongo, was done in total disregard of the applicable laws and regulations. And then finally we said, the affidavit by a member of the SSA who implemented the approved submission confirmed that the member concerned was appointed as a result of the aforesaid submission as approved by Advocate Bongani Bongo MP in his then capacity as the Minister of State Security. It was indicated to the Minister that with the evidence collected thus far by us, it was clear that the appointment of the member concerned was irregular and unlawful. No useful purpose was going to be served by approaching the former minister and interview him. And then we sent that particular letter. Now, this is a significant point. Since then, the minister has never reverted back to us.
Just to summarize then, you gave evidence last time of an appointment which was called into question by your office.
That's correct, Chairperson.
As being irregular.
That's correct.
You conducted an investigation and made certain recommendations.
That's correct, Chairperson.
The Minister, Minister Lord Law, raised what appeared to be procedural concerns about who had been heard and who had not been heard.
That's correct.
You responded to those complaints, maintained your recommendation, and the matter was, from your point of view, not resolved.
That's correct, to date.
If we could go over the page then, please, to page 813. You deal in the paragraphs on that page and over the page with appointments to the cadet program and to other portions or departments within state security. Paragraph 122, just very briefly, what happened in relation to those appointments there or recommendations?
It is a generally accepted practice amongst intelligence services that sometimes they will want to identify intelligence officers at an early stage. They could visit high schools, they could go to the universities and start recruiting there. And what they've done here is that in certain instances they will identify the so-called underprivileged or previously disadvantaged students or individuals. They'll give them a bursary and then they will go and study with already a commitment at that stage that they will be absorbed into the agency once they complete that. Same principle with the cadet program as well. So they've done a lot on that. Like a single cadet program could have around 30 or even more students who will be taken to the college. We do not have a problem with that. It's a good practice, accepted. The only problem is that they do not have a criteria which says what are the requirements, basic or otherwise, that these cadets or students should comply with. And that is creating a serious problem because there is evidence, even in the high-level review panel, which concludes that the SSA has been turned into an employment agency for the politically connected as well as those who are connected to the senior managers within the state security agency. And we cannot question that as an oversight, because the thing that we should be doing is to say, what is the criteria, and check really whether that criteria and the procedures were followed when recruiting those people.
All right. You've given the examples in paragraphs 122 to 124, and the facts are set out there. But in principle, what is wrong if a Minister of State Security suggests a particular candidate for a cadet program with the undertaking that that person will then be employed by an SSA? Surely a minister can identify a person suitable for such appointment on his or her own. What is the problem with this ministerial overreach, as you call it?
The problem is that more often than not, we have stumbled across, or in fact, we found that there would be familial relations between people who are appointed, between them and the political principals, and in certain instances also with senior managers within the state security agency.
What about,
yes,
you don't
for
mention...
For us, it's nepotism, and we cannot really deal with that issue satisfactorily until we know which criteria was used to identify them.
Right. So that the danger of nepotism you do mention as a general point, but in paragraph 122, you do say there are other instances of the children and family members of senior politicians and ministers being appointed to these cadet positions. You do mention that. But the particular examples you give here are not examples of nepotism.
They are examples of nepotism. We decided to remove about 2 names.
Oh, I see. Of course.
For the reasons of the time, the pressures of time, chairperson, and we are also trying to limit the notices that we have sent. But in the documents that will be declassified and transmitted to yourself, you will see the names, the surnames, and that relationship.
I understand what you're saying.
So we will get that information.
It is in the documents that I've submitted to the Commission already.
Okay.
Right.
Okay.
The second point is, what are the issues around the future loyalty of the SSA member? The cadet becomes an SSA operative, about the potential of partial loyalty to the person influential in his or her appointment. Is that a problem?
That is the problem, and I think that I would have raised it earlier as well, to say that they become beholden to the appointing authorities, and they are ingratiated in particular manner, because some of them will tell you that I didn't expect this, you know. Just imagine how easy it is, chairperson, if I get identified, I'm given a bursary, I get appointed, but our neighbor's child, who may even be more qualified than myself, is not really considered for that position. It's obvious that I will be beholden to the appointing authority.
And then, in addition to that, you have testified to the chair that you're not clear whether the requirements, the appointment requirements, were actually followed in each case.
That's correct. We wouldn't be able to establish that because each time we request the criteria, they say we do not have the criteria.
But how rife is this problem of appointments that are done in this way, particularly those that seem to have features of nepotism? Roughly, do you have some idea? Are we talking about 2, 3? Okay, in instances, are we in a year? Are we talking about over the past 5 years, 50 people more or less? Do you have some idea, or is that difficult to say?
It is a frequent practice, Chairperson. In fact, when I was drafting the affidavit and I wanted that documentary proof, I was given a list of about 40 cadets, yes. And at that particular point, I'm informed reliably that the then Minister of State Security, Minister Castrals, I'm not implicating him, so I think I can mention the name, he actually disowned those students because he said that when he was going through the list, he could pinpoint exactly that minister, that other former minister, that other minister, that other DG, that deputy DG. So he disowned about 40 graduates on a cadet program. The other ones, it was actually 2 students who had gone to university. But then the reason why I focused on that, it is because they would have written to us now complaining in turn that they were not placed on a level that they were promised before they went to university. It's a very, very, very frequent issue at the State Security Agency.
Do you have an idea as to whether there is a number that they seek or a target that they seek to achieve per year, that they must have got X number of people that will go into this training and then later on get employed by SSA?
I do not remember. I think that we made that inquiry, but it should have been included in their annual report, if not their plan, the so-called annual performance plan, APP. But we could not get that kind of information. So I do not know in any given year how many people are they targeting to recruit.
Because it would be good to have an idea whether one can say over the past 5 years or even more, it looks like on average per year, so many people get put into the program, even if to the training with a view to later being employed by SSA, even if not all of them are people who have been employed due to nepotism, but people who go into that programs to see its size.
Yeah, I'll not have an intelligent, response to that.
No, that's fine.
I didn't work that out.
It can be finished later in writing if it's information that you can get.
Maybe safe to indicate that it is also happening loosely. In that you will get, and I read the names of the ministers, you'll get Minister David Mahlobo, who will visit a particular high school in KZN, and then he identifies maybe 3 or 4 students. You will get the then Deputy Minister, I'm mentioning her name, Mrs. Mulekane, who will go to a high school in, and I'm exchanging provinces here, to the northwest, and identify 2 that we have that particular information. And then you will have the Director General, then who will have a program of about 30 or 40 at any given time, then being sent on this cadet program. So it's happening because there's no criteria. Other people are going, and where we are sitting now, we may even be oblivious to some of those cases.
Okay. Mr. Pretorius?
Just in summary then, as a matter of principle, at the bottom of page, or at the end of paragraph 123, on page 813, you say this involvement of the ministry in the recruitment process constitutes significant executive overreach into the functioning of the SSA. And as I understand it, you've raised at least 3 problems. One is question mark around proper qualification.
That's correct.
And adequate suitability of the candidate for the post being properly assessed. The second is that there would be a potential of the relationship between the state official or the minister and the operative being exploited, I suppose both ways. Is it possible that the operative would be loyal then to the minister? and the minister could exercise influence over the operative. Is that a valid observation that you make?
It is an observation that we confirm, and maybe can I give a final example of what happened in terms of the executive overreach, and this is the matter that we are dealing with now. Now, the State Security Agency starts writing a submission, and that submission appoints 26 managers. Now it's senior managers, they use their own levels there, but I think that in the public service it would be your directors, and because there are also general managers who could be equivalent to chief directors and so forth. Now, this is the case that is confirmed, but what happens there is that they do not advertise it. There is no selection panel. There are no interviews. Some of those people do not meet the requirements of that particular post. The acting DG then even refused to recommend because he's writing his consent about how these people were identified. 26 chairperson, managers. And the only thing that you find in that submission is that they have a block where they write a motivation. One example of that motivation is that this person used to act that particular position, and he's a loyal member for years, and he has experience on that particular field and so forth. And then they got appointed. Some of them, and what the DG wrote under the comments is that some of them were even recalled from retirement, and then they were appointed again. There is no regulatory framework. When you go through that particular submission, they did not tell you about this, any legislation which empowers the minister to appoint, but it's the minister who then appoints this group of 26. As I'm talking to you, they are in their positions.
So are you saying that there is no legislation or regulation that gives power to anybody, whether it's minister or DG, to say this can be done?
The way I see it, or Chairperson, sorry? Yeah, the way I see it is that the minister was intending to come up with what we call a deviation. So the regulations are in place, and they couldn't quote those regulations because regulations says you advertise, you come up with a selection criteria, selection panel, you follow those steps. That's what their own regulations are saying. So they didn't write any of those there. The only reason that they provided under the motivation is that there is a huge number of managers who have either resigned, went on retirement. In fact, coming up with what one could see as an emergency recruitment. So in my career, I've only heard about emergency procurement when there is a best pipe somewhere and so forth. But I've never ever heard of an emergency recruitment.
The legislative provisions that you have in mind about advertising and so on, I think those would relate to the actual appointment of these people, isn't it?
That's correct, Chairperson.
Yes. What I was more concerned about is how they come in, because based on your evidence, it's like they first have to get into some training, or they get bursaries on the basis that once you have got whatever the qualification or training is, you will be employed. So I was asking about any legislative provisions relating to the granting of those bursaries or whatever the program is. Do you know anything?
Yeah, no, in that case they do not have, and I'll request the Chairperson to delineate the two that I was talking about.
Okay.
The latest example that I was referring to is people who are long in the service.
Oh.
Now that are appointed into management positions.
Okay.
I had exhausted,
Oh,
at
you had
least
exhausted
in
the
the meantime,
earlier one.
there's cadets and the
Oh,
students.
okay.
Yeah.
But the cadets get bursaries to get some training or whatever, and then they get employed afterwards. Is that right?
That's correct, Chairperson.
Yeah. So, okay, that's where I was still on. And you say that one has got no legislative provisions, a framework as far as you know.
It doesn't have, and that's what we've been requesting.
Yes.
Even if it's a policy which deals with the criteria
Yes.
to be considered.
They don't have.
They do not have that, Chairperson.
Yes. So it's like somebody just decides it's a good thing to look around and give bursaries sometimes to people who seem to be deserving, and then it's done.
That's correct, Chairperson.
Yes. Okay, but the latter category you were talking about is people who have been in the system but not in certain positions, and then they are promoted to certain positions without following any processes.
That's correct.
Okay.
And in that instance, there are regulations
There are
which
regu-
deals
yeah.
with that, but they get ignored
Yes.
completely.
Yes, yes. And in regard to that, both ministers and DGs are involved as well in the breach of those regulations.
In the latter example,
Yeah.
the acting DG refused to recommend,
Yes.
but the minister went ahead and approved
Yes.
the appointment. As I'm
Yes.
talking to you, those people are in those positions.
And that's about how many people?
26
26.
managers.
And which minister are we talking about? in regard to
Minister
this?
Ayanda Dlodlo.
Yes, and how recent is that? Those appointments, how recent are they?
They are yet to get their first salary, Chairperson.
So it's something that happened after this commission had some evidence about some of the challenges in SSA.
That is correct, Chairperson.
Yes.
Yes.
Okay, all right. Mr. Pretorius. And I'm sorry, Mr. Pretorius. Have you got any understanding with regard to this category? Have you got any understanding why ministers and DGs would act in breach of the regulations in regard to these appointments when they know them? Do you know why they would be doing this?
I do not want to give you a conspiracy theory.
Yeah, okay, all right.
I don't want to give you
Okay.
that, Chairperson.
Okay,
Yeah.
because it can't be that they don't know, I would imagine. They must be knowing the regulations. You don't want to say anything?
All right. And I think with one of those appointments, there was a media opinion. There's an opinion in the media. Those people are connected, majority of them are connected to the previous management, the management that would have worked with Mr. Arthur Fraser during that time. People are able to point, and there is a belief that they are coming back and reforming in the State Security Agency. Yes.
Okay. Mr. Pretorius.
The previous period you're referring to, is that the period covered by the PAN 1 report, Principal Agent Network 1 report, that period?
During that period, that's correct,
Right.
yes.
And the allegation, and it is an allegation for the moment, we may deal with it later, Chair, is that people who were implicated in the PAN 1 report were reappointed to the SSA.
That's correct.
Is that what?
Maybe we should not call it reappointment. We should
Promotion.
talk about promotion. So during PAN 1, they would have been in a level below the level that are appointed to now.
All right. So it's promotion you're talking about.
That's correct, Chairperson.
Just to summarize then, the cadet program, the bursary program, has as its outcome appointment into the ranks of the SSA. correct?
That's correct, Chairperson.
And you've given examples of ministerial involvement in the selection and appointment, informally, of course, into that program.
That's correct, Chairperson.
And your concern is that the proper procedures are bypassed in that process.
That's correct.
In relation to the 26, you speak about irregular promotions to senior positions within the SSA.
I confirm that, Chairperson.
But all these are done under the direction rather than the recommendation of the minister, as I understand what you're saying.
The approval of the minister. So the minister is the last signatory. And it will be written, like on the submission, to say that recommend, not recommended. So it will be the other signatories. You'll get an HR official somewhere, but the last part there is approved or / not approved. And the minister, the appointments happened under the approval of the minister.
But what's wrong with that?
Exactly what I'm saying, that the involvement of the ministry in the recruitment process constitutes significant executive overreach. And this is not, cannot be seen as my opinion only because it is also contained in the HLRP.
So, as I understand it, the minister doesn't approve finally, but is involved in the process leading up to his or her own approval, irregularly.
That's correct.
In paragraph 124, page 813, you record an interesting observation. You say, this was also the case in the Free State Provincial Office of Crime Intelligence, where the provincial head, Major General Makele, has acknowledged this practice. According to her, the appointment of children and family members of senior police officials, as well as a girlfriend to one of her brigadiers, assisted in ensuring that they recruited trustworthy people. These members were then placed in a very sensitive environment without the necessary experience to the detriment of crime intelligence. Leave aside the formal qualifications issue which you raise in the second sentence, but are you then aware of the statement actually being made that family members are appointed because they're trustworthy?
And I'm still shocked, even today, Chairperson. But what happened is that when my staff members go and do what we can call like verification, like when they visit these offices, I sometimes accompany them, and we will deal with, or we'll have a meeting on the first day, and then I will leave them because sometimes they will work there for a week or so. So in this specific meeting, I was sitting there with the provincial head, Major General Makele, and I posed that question just from myself to say that, but we are informed by somebody in that meeting, in fact, a component head responsible for counterintelligence, because counterintelligence in the SAPS will investigate the other officials within crime intelligence. And I sought her response to that. And that is the reason that was given to myself, because the names were mentioned, and next to each name, it will be a station commander of that station, police station in Bloemfontein or around the Bloemfontein area. It will be a major general somewhere in the provincial office. It will be a brigadier in the same office whose girlfriend is appointed in that space. And then you will also have a relative of Advocate Makele herself. And the reason that she provided to us was to say that these children or these kids are well bred up, because they belong. I mean, they are children to senior officials of SAPS and so forth. And that was the reason that was provided to us. I'm still in disbelief even to date that that was the reason used.
Right. You go on in that paragraph to say that there has also been a complaint that because they, and I presume it's these appointees, owe an allegiance to the provincial head, they only share the intelligence that they gather with those members of management to whom they owe allegiance. Is that a complaint you received?
That is the complaint that I received. May I please paint this by using alphabets, if you allow me, Chairperson. Now, you will have A, and A is a head of counterintelligence. And then you'll have B, who is a head of surveillance. Now, because this group falls under this other group of B, for instance, they will then provide information only to B, so that B could appear more successful than A. So they will be sitting there, and I'm just being careful because this is one of the methods that they are doing. But let me use a cynical or simplistic example. Let's say they're responsible for listening to conversations. And they come across, for instance, people who are planning to commit cash in transit heist, for instance. Instead of giving that information to A, they will not do that, but they will rather give it to B, because B was on their side and would have influenced their appointment. So that kind of a competition also exists, and which poses a serious problem then, because it means that the other people may not even come across that information.
So do I understand you to correctly to be saying that one of the principles of employment in state security, particularly, and I presume it applies throughout the public service, is that the person appointed must be completely independent of external influence?
That's correct.
Particularly influence in regard to their appointment in the first place.
That is correct, Chairperson.
You go on in the next section, paragraph 125 and following, to deal with the controls relating to the use and flow of money in the intelligence services. Now, we've heard detailed evidence in this regard. You give evidence of a more general nature arising out of your own experience and investigations. What have been your findings? You deal with that in paragraph 125 and following.
Yes, and Chairperson, yes, I think that I need to start by confirming that indeed we would have removed specific transactions because amongst your witnesses, I think that Mrs. K detailed all those. We do have also a detailed list of money flows. What I can confirm is that money has been stolen, and we are talking lots and lots of money taken with suitcases, others being lost, and people were never really held accountable for that money. And what I'm saying there is that our findings is that these monies have been used for other things that, in fact, could affect our national security adversely. For an example, some of those monies could be used to fuel political tensions. There is evidence in our possession that some of those monies were used to finance a particular faction within the governing party. And in other jurisdictions, you find that these monies can be used also to finance terrorism.
Right. Paragraph 126, you go into a little more detail. Would you deal with that? But before you do, the documents that you are yet to provide in the various bundles supporting your statement, do they contain more evidence of this?
they do contain itemized, Chairperson, itemized, the items which indicate at what stage was this amount taken and what reason was given. And I even attach examples of what could be seen as an invoice. In other words, purporting that the recipient would have received the money.
So that documentation, we trust, will be forthcoming, hopefully as soon as possible, Dr. Dintwe.
That is correct, I confirm that.
There's paragraph 126, you go into a little more detail.
Yes, and I also refer then to that. I think, I am aware, Chairperson, that during the evidence of Mrs. K, you were shown an example of a Word document. So I take the money and say that I'm taking this money to Joseph. Joseph could be a source, or he could have done certain work for us. And what I do is that I only type, the undersigned, confirm that I've received this particular money, and then there is just a signature. No letterhead, no nothing, and so forth. And we are talking huge amounts of money. One of the transactions was equivalent to 200,000 euros at a go.
Who is quick to work out how much that is in? Is it multiplied by 8 or 10 or some 10 it in convert into rands? 19.
It is 18. It is 18, standing around 18.
I haven't traveled in a long time.
It runs into millions.
It's roughly?
It ran into millions, at the time that I was doing that calculation. To be, what I found at that particular point, I know that it's fluctuating, but it was 2.7 million rand. Yes, that was taken by a member, and it just got lost, just like that.
And there's no proof of what it was used for?
Not at all, Chairperson.
Right, you're saying, firstly, that the use of cash is inherently problematic, although it might be necessary. I think that's been conceded by you elsewhere. But it's the accounting and the documentary records in relation to the disbursements of cash that is of concern. Is that correct?
That is correct. And also to add that managers deliberately or being unaware tend to misconstrue secrecy and the permission to use cash to mean that then it's non-accountability. There must be an authority somewhere where you go and account. So they see that kind of a thing to say that once you say that you can use cash, then it means that you may not, in fact, account at all. And that is what is happening.
So it's a tap that must be closed without jeopardizing the effectiveness of intelligence, proper intelligence, and the use of cash legitimately for intelligence purposes. But close the tap and for those who can just take money and they don't have to account to anybody as to whether that money was used properly.
That is correct, Chairperson, but they will never ever be able, all intelligence services will need to use cash in certain instances. But yes, of course.
The legitimate part of using cash, that must continue. The problem is to close the tap of using it illegitimately.
That is correct, Chairperson.
Yeah, because one can understand why cash may have to be used for legitimate intelligence purposes. But one must close the tap if one can in regard to people being able to just take money and go and use it for whatever they choose to use it for and say it was for intelligence purposes and their word must be accepted.
That is correct. That is our proposition,
Yeah.
Chairperson.
Yes, we'll deal with an extract from one of the reports you actually made in this regard over the page. But for the moment, if we could stay in paragraph 126. You say you raised concerns about the prevalence of large sums of cash being withdrawn at the SSA, and that is in relation to the 2017 financial year of SSA operations. And you say this concern was raised following claims that large sums of cash were being carried out of the SSA by members sent by senior management of the SSA to various destinations between 2014 to around 2017, with limited proof of receipt of those monies by persons at the purported destinations. Are those the claims that were made to you, your office?
Yes, but we would have investigated them. So what we include in our certificates, remember the certificate that I referred to last time? Yes, it will basically be findings, not really. So we would have received a report and we will get into the system and check whether that money indeed went out, and we will check whether there was some kind of invoice or settlement of that particular money. So what I list in the certificate will be our findings to say that this X amount of money went outside, and we do not have proof that it was really received by the intended recipient.
Right. Now, these claims that were made, complaints that were raised with your office, you say you investigated and you made findings.
That is correct, Chairperson.
And those findings highlighted concerns over the use of cash and the improper or inadequate accounting for that cash.
That is correct, Chairperson.
Now, you say that you raised these issues in certificates. Who receives your certificates?
Firstly, it will be the minister responsible for a particular service. In other words, Minister Becky Cele will get on behalf of the police of SABC, Minister Mapisa Ngakula will get on behalf of Defense Intelligence, and Minister Ayanda Dlodlo now will get on behalf of the State Security Agency. That is the first authority. The second authority will be the heads of services. So it will be the DG and the divisional heads, commissioner. In the case of SABC, it will be Chief Defense Intelligence Officer in that other case. The third authority will be the Joint Standing Committee on Intelligence.
Now, in regard to the latter, without the intervention of the Minister or the Director General or Acting Director General, as the case may be in each security establishment, there is a direct reporting between your own office and the Joint Standing Committee of Intelligence. Do I understand it correctly?
You understand me correctly.
What did the JSCI do on receipt of these certificates in relation to the improper use of cash, as you found?
The previous committee really never acted on this.
You know why?
One of the other reasons that was provided at a particular point was that they want to really keep the separation of powers. For them, they saw these as the decisions which happen within the executive realm. And I don't know to what extent they were intended to hold those executives to account. But as far as I know, is that I was never really provided with a reason, a convincing reason, let me say that. I was never convinced as to the reason why they could not act.
You conduct in your office an oversight role over the executive, correct?
That is correct, Chairperson.
And you do so independently?
That is correct.
With your knowledge of what oversight entails, are you satisfied that the JSCI performed its functions adequately?
No, not. I can say and submit to the chairperson that no, that is not sufficient. There are oversight roles.
I thought you were tempted to say, I can say without fear of contradiction, that they are not doing their job.
No, Chairperson, I can say confidently that the oversight was never adequate. The reason why I'm saying I'm confident about it is that it is also a finding of the HLRP in any event. But I think that there is evidence before this commission as well to say that parliamentary oversight was not adequate.
Now, with regard to this particular committee, are you basing your view on your experience during your term of office only, or are you also basing your view on records or lack of records that you found in your office as to interactions between your predecessors and this particular committee? Or what is the position?
My preference was to confine this to my term of office, because I think that even statisticians will tell you that it's I've been there for a sufficient time to can be able to formulate an opinion, but to also formulate or identify a particular pattern. So I mean, I've been there now for 4 years and a couple of months.
That's a long
so I confined myself to my term of office.
By the way, who was your predecessor?
My predecessor was Advocate Faith Khadebe, the late.
Oh, she's late.
Yes.
So she would have been there from what? From around 2010? Is it a 5-year term?
Yes, I'm writing about, it's a 5-year term.
Yeah. And then there was a space of 2 years when there was nobody.
That is correct.
Before your time, before you were appointed.
Correct, yes. I think in my earlier paragraphs here, I've written which years, but 2010 sounds more probable.
Now, if I'm trying to find out how one can find out, even without asking the committee, find out as to what may have been sent to the portfolio committee by, for example, Ms. Khadebe, and what responses, if any, she may have received in response to her reports. What did you call them? What do you call your reports?
Certificates.
Certificates, in regard to her certificates. So in your office, you would have copies of certificates that she would have sent during her time, is that right?
That is correct, Chairperson.
And but in terms of the mechanisms, you don't have a way of knowing whether the committee acted upon each certificate, do you?
No, but I will know.
Yeah.
By implication.
Yes.
Because there is continuity in the office.
Yes.
It's only the Inspector General of Intelligence who gets appointed, who comes and goes.
Yes.
The rest of the staff and very senior people, including the investigators, are always there.
Yes.
Now, during my first year in the office, and when I started dealing with my first certificate, there was a reference made already to the recommendations that remained unimplemented and were coming from the tenure of Advocate Khadebe. There are many examples of that. In fact, the so-called rogue unit at SARS and so forth, I still had to deal with that issue after I have taken occupancy of that office. So I will have a group of certificates which will show what my predecessors sent to the committee. But those problems will still be applicable under my term of office. Like, for instance, the one that I'm writing there, inadequate controls relating to the use and flow of money in the intelligence services. You find those things also under the certificates that were drafted or that were signed before I assumed the office?
Well, I think this is how we can deal with it, and maybe you do deal with it in your affidavit. Maybe we dealt with it last time, Mr. Pretorius will remember, or maybe it's still to come among the documents that you will send. I think it would be good if you were able to say, I have looked at the certificates that were sent by my predecessor from that year up to that year. I'm aware of what she recommended or whatever, what issues she raised for the committee to look at or deal with, as well as the ministers, the relevant ministers, because we have said that the certificates goes to minister, the relevant minister, the relevant DG, and the committee. So if you could identify those for each year and be able to say the following, this problem that was raised during that year is still there, or when I arrived, it was still there. So I can tell that nothing has been done to deal with it properly. So, or whatever has been done hasn't worked, you know. So I think that could help, just to give that indication. In terms of law, there is nothing that requires the committee or the relevant ministers and DGs to revert to your office to say, you raise these issues, this is what I've done in response.
I think my submission last time, Chairperson, was to say that our recommendations are just being ignored,
yes,
willy-nilly, and we touched on the PEN 1 investigation. Maybe this is a specific example, and I'm using this example to submit to the Commission that it is doable. It's an exercise that I think that if I go back to the office, I can readily identify to say that this has been a problem for time immemorial, or since the establishment of this particular office. Let's take an example of what one of my staff members will be writing an affidavit about that I discussed, and I think it is in here. Now, former Minister Mahlobo says that he was not aware that Mr. Arthur Fraser was implicated in the PEN investigation. And I went to the office because the Commission wanted us to confirm whether there were some presentations made to the minister with regard to the PEN investigation. So the same recommendations in the PEN investigation was that people should be charged, for instance. So that's exactly what, it's a classic example, and I think an accurate example of saying or being able to promise the Commission that it is a doable exercise to go there and say that these were the findings before even my occupancy of the office, and they were never ever implemented. In law, I don't think that there is a recourse for us as an oversight body.
Yes. Well, of course, I think you suggested last time, or you do in your statement, that I think you wish for a regime in terms of which your recommendations can't just be ignored, but they would be binding. I got the impression you had in mind the same situation as the public protector, but I may be misrepresenting what you say. But certainly, the minimum, it would seem, is that those authorities, when your office has raised issues and made recommendations, they should at least come back and say, we have noted, we agree, and this is what we'll do, or we don't agree because of the following reasons. So you can take it from there, but to have a situation where they are just completely ignored and you never know whether they did anything seems untenable.
You're not misrepresenting me, Chairperson. You've got a very sharp memory.
Yes.
Because that's what I was saying, and I was saying that I think that we do have a good model to say, are they remedial measures? We know that they are not. But I was even saying to yourself that I wish that we had resources, because I was going to take myself to court and say that I don't think that any legislature will have an intention to put some money into this organization, but then recommendations are just being ignored.
Yeah.
Yes, that was what I said.
Okay. Mr. Pretorius?
In paragraph 127 on page 814, you cite two examples. I'd just like to ask whether you confirm those. You say in one instance a member claimed that he had lost an amount of approximately 3.6 million rand while on an operation. This is clearly absurd. A further finding was that since 2016 there was an SSA member who had been submitting fraudulent travel claims amounting to 9 million rand. Do you confirm that those were findings or investigations conducted by you?
These were findings, and I write there, I say this is clearly absurd, because what came to attention was that in the 3.6 million now, there's a gentleman who goes on an operation to Jupiter, this other planet, and he comes back and says that I've lost it. They've taken it, or I misplaced it, or whatever. But then he doesn't even create serious attention or attract serious attention, because he then tells them that I've lost it and you can deduct it from my salary. In fact, the gentleman went on an early retirement during the course of 2020. And others will know that their pensions will not even get to that particular amount. And in this instance, he just came back and said that, I've got no reasons. I've lost it, and please start deducting it, and so forth. I'm told that they're deducting that money, and they would have attached his pension, if not part thereof. Now, there's a problem, and it came in the analysis of our evidence. If I got 3.6 million and I went and bought a property, I will be saving about another 100%, because if I'm buying a property for 3.6 million rand and it's bonded, I'm going to end up paying about 7 million rand. But if I buy it cash and I say that, no, you can get that money from my pension, it means that I would have received an interest-free loan to do other things. That is the first example. The second example of 9 million rand, it is a finding also. This person is a protector. He's a protector who accompanies a principal when he travels both internationally and locally. And our findings is that this person could not have pulled this mission alone, because it's very easy. If I'm not traveling overseas, but then you get my protector coming to claim money that they would have traveled, it should be well known that no, but Dintwe did not apply to go to this and other country and so forth. So it happened over a period of time until he reached an amount of 9 million rand. Inadequate controls, and there is an argument about that, because other people will say absence of internal controls. No, in this instance, controls are there, but they are being ignored as well.
And this would have been in a period of about how many years to have that information?
3 years on average, a travel of 3 years.
So it accumulated to 9 million rand within 3 years.
That's correct,
Yeah.
Chairperson. Yes. It also tallies with the usage of cash. I will never understand why they give me cash when I travel outside the country. I just don't know, because it's even risky. I am called an Inspector General of Intelligence. I'm not collecting intelligence. I'm not doing anything. I am an oversight body. But believe you me, when I travel, they give me that kind of cash. So when I come back, normally I will return it some.
Not millions.
I beg your pardon?
Not millions.
No, it will not run into millions. Yeah.
Yeah.
Yes.
Yeah.
Is this a convenient time, Chair?
It is. Let's take a 15 minutes break. We'll resume at 11:30.
Thank you, Chair.
We adjourn. Okay, let's continue.
The examples that you've given to the chair, Dr. Dintwe, both at a general level and at a particular level, were these included in the certificates that were given to Parliament and to the Minister and the heads of department?
I confirm that, Chairperson.
In paragraph 128, you raise a concern about the possible use of these monies. What do you say about that? That's on page 815.
I'm saying that they were used to fuel or to finance a particular, a particular faction, depending on who is taking that money. Our finding in that regard is not one-sided at all.
So it's like different people may have taken monies to finance different factions.
That is correct, Chairperson.
And that information too would be in the certificates,
It will be in the certificates.
having been reported to Parliament,
That is correct.
or at least to the Joint Standing Committee on Intelligence.
That is correct, Chairperson.
You say in paragraph 129 that you made certain recommendations in a report, and you talk of one of your reports. Would this report have been included in your certificates?
It is certificate. I think that I used the word report interchangeably there.
Okay, so it was
And-
a certificate reported to all those instances to whom you've referred, including the JSCI.
That is correct.
Right.
Wouldn't you like me just in one or two sentences explain why I would have used the word report there? So, over and above the certificates, I also do what is called monitoring reports. Now, monitoring report, I may take just one subject, because certificates will deal with issues, a variety, a plethora of issues. But in this instance, I may decide to do a monitoring on procurement, maybe of software, for instance, and just write that particular issue, and then I will send to a responsible minister.
Would those reports go to Parliament?
They will then go to Parliament because a certificate is a culmination of your review reports, monitoring reports, outcome of investigations. So even if I would have sent only this subject right in the middle of a reporting year, it will then be found in the certificate as well.
Right. Perhaps you should read onto the record your recommendation in paragraph 129.
I'll do that, Chairperson.
Thank you.
I say, whereas the movement of large sums of cash is justifiable within the context of secrecy of operations, there is a need to ensure stricter controls to ensure full accountability for cash given to members for operational purposes. However, the veil of secrecy associated with intelligence operation does not make any public servant immune to accountability and sound financial management. Hence, the person who claims any money or uses the resource of the SSA is required to settle such in accordance with applicable prescripts. During oversight engagements, I came across a number of instances where the monies are not properly accounted for. I am aware that even the SSA internal investigative units are currently working on several cases where money is not accounted for.
And then you go on in page 815, paragraph 130, to talk of recommendations that you made in your capacity as Inspector General of Intelligence. What were those?
It was that although the control measures are there, they need to be tightened a little bit because some of them were too old. And
Just a little bit.
old for my liking. In any event, even the Secret Service account, I think it was it's 1957 or so.
Now,
a
did
piece
you
of
use the word
legislation.
a little bit? Were you just the figure of
Maybe
speech?
too old. Yeah, but my intention was to say that they could be a little bit old, just too old for our liking, and that.
But I think Mr. Pretorius is suggesting that in the light of what appears to be large-scale abuse of monies that should be used legitimately for intelligence, the tightening shouldn't be or can't be for just a little bit. Much more is required. I think
Yes,
you are
but
suggesting
yeah,
that,
my quagmire is that times will differ.
Yeah.
So they would have amended 1 out of 15, maybe in 2009. They would have, adjusted 3 or 4 in 2014 and so forth. That's why I cannot use an umbrella word that's too old for us.
Yes, we've heard the evidence of Mr. Jafta as to what steps have been taken more recently in relation to financial controls. But it appears from your evidence that what you are saying is a substantial review of control measures and their implementation is required within the SSA and other intelligence organs.
That is correct, Chairperson. But I also said in this instance that they must be both preventative and deterrent.
Right. And you say that steps should be taken to recover outstanding temporary advances from members who have not settled those.
That is correct, Chairperson.
Now, all these issues concerning financial controls, the absence of financial controls, the loss of state security monies, the inadequate controls over the use of cash, and which you have now highlighted over the last hour or so. Your report, or your reports, or your certificates forwarded to the JSCI and the ministers would contain detail in this regard.
That is correct, Chairperson.
And would contain detail in regard to your recommendations.
That is correct, Chairperson.
How is, and these questions I've been asked to raise in relation to further evidence to be led by Advocate Freund, where I've spoken to him in the break, Chair. To whom does this report go? In particular, does it go to the Secretary of the JSCI, the Chair of the JSCI?
We address them to the Chairperson.
Right. Who is the Chairperson of the JSCI, or who was the Chairperson of the JSCI at the time you would have been submitting these reports?
Previously, it was, now there is a previous committee, the immediate previous one. It was Mr. Charles Ngakula, who then was transferred to the presidency as a security advisor. And during that particular time, there was an acting chairperson, Mr. Gamede, and we then also, Mr. Gamede acted for a while, where the current one is Honorable Make.
Now, this is a multi-party committee, as I understand it.
That is correct, Chairperson.
And did you ever have occasion to speak to any member of the JSCI and say, what's going on? Why are you ignoring my recommendations? What are you doing about my reports? Was there any interaction of that nature, either in correspondence or verbally?
I wouldn't address any formal letter to any other person except for the chairperson. But I cannot rule out that there could have been a discussion between myself and one of the members, because they also had an open line to myself. In fact, one of the people that I remember raising these issues with is General Bantu Holomisa, because he was sitting in the previous committee. But apart from that, there's also a chief whip, a deputy chief whip in Parliament, that I also have that kind of an open line. So we would have had those discussions about this issue.
So you would have, in discussions, raised concerns about your certificates, how they were considered, and what was being done in response thereto?
That is correct, Chairperson.
Are you able to say, do you feel comfortable to say what General Holomisa said to you?
General Holomisa said that he is aware. Normally he will sort of give me counsel, such as, you have to be strong, we are aware that you are doing your work, and perhaps he could have promised me that he will see how he would nudge the chairpersons or the committee itself in its entirety to really implement these things. Because all these people that I would have, talked to, they were aware of the rot that was deepening, especially in the State Security Agency, but also in crime intelligence. So they were not oblivious to those. Can I say that there is an interview that was done by one of the current members, Dr. Mbuyiseni Ndlozi, who said in that interview on TV that he is aware that we are doing what we are supposed to be doing, but the failure is at a point of implementation by the committee itself.
But somehow it seems that even though different members of that committee may be aware, including members of opposition parties serving on that committee, may be aware of the problem, it looks like they can't get action to be taken by the committee. Because from what you have said, it looks like no action seems to have been evident or seems to be taken that is effective. At least if anything has been done, it seems not to have been effective. But
that is my
can't
submission.
tell what it is that may have been done.
That is my submission, Chairperson.
Yes. And one doesn't know whether it might be the same problem that has been experienced by some portfolio committees in Parliament in regard to oversight, where members of opposition parties say we can push as far as we can if the ANC members of the party who are in the majority don't agree. We can't do anything because the decision must be by majority. So one doesn't know whether that is the situation with this committee as well.
Well, whether that's a satisfactory explanation or not, from a member of Parliament, is something we will make submissions on in due course, Chair.
No, that's fine. Thank you. Let's continue.
But in summary then, the problems that you've raised, the impropriety, the illegalities, the loss of monies, the inadequate accounting for monies, the looting that you've spoken about, the improper use of monies in factional battles, those are all in your reports?
They're all in my reports, Chairperson.
No member of the JSCI can claim ignorance of what you have reported to the JSCI.
Not at all, because to confirm that, I would have submitted the certificates in a redacted version to the chairperson. All what I removed was methods that they use, sources, but I also removed organizational weaknesses. But in terms of the transactions, I made it a point that the commission, becomes aware.
So when we get those certificates, the chair will be able to see exactly what the JSCI knew, apart from the redaction.
That is correct, Chairperson.
Would you be able to say whether, because of the reduction, the reductions that you made, there would be nothing wrong with those reports now? I can't remember whether they're classified or not, your certificates being available to the commission if those reductions have been made? Or there would still be a problem even if there are reductions?
No, there wouldn't be problems because I deal with administrative issues.
Yes.
With regard to procurement, for instance.
Yes.
And I think I would have made submissions earlier or later to say that there's generally overclassification and it is done to hide malfeasance.
Yes.
So I've worked on the certificates to an extent that I am satisfied that they can be made public also. That is the reason why I would have removed the other issues.
Yes. Well, I would be very interested in seeing those certificates, those reports, insofar as one can look at them without any problems in terms of security and so on.
Thank you, Chair.
Chair, our understanding, we've looked at this quite carefully and have consulted externally as well, is that you would be entitled as chair to see the unredacted versions of the certificates.
Yes, okay.
However, for the purposes of your report and whatever goes public, the redacted version would be necessary to be revealed.
Okay.
Provided, of course, the person in control and who has the lawful power to deal with it agrees.
Yeah, okay. No, that's fine.
And that is Dr. Dintwe.
Yeah, no, that's fine. I think it would be important in order to get the full picture. Whatever can be dealt with publicly without being in breach of any law, it would be good to look at that. Whatever I can look at out away from the public, that might also be important if it can be done.
We'll consider the position.
Yeah, okay.
I have considered that position. It is, in fact, my administrative decision that I sent to the 4 functionaries that I consulted with to say that there are 2 levels of disclosure here. The first disclosure is to yourself, Chairperson, and maybe I also mean the legal team. The second disclosure is then to the public.
Yeah. Okay.
Thank you. All right. In paragraph 131, page 816, you deal with what is another serious issue in your terms in relation to crime intelligence. And you say in paragraph 132, our investigations have revealed that the systematic and endemic institutionalized looting of the Secret Services account is carried out and perpetuated by senior managers within crime intelligence and their trusted subordinates under the guise of legitimate intelligence operations in order to avoid culpability and accountability in the event of detection. Now, these issues, or some of them at least, are in the hands of law enforcement agencies at present. But would you tell the Chair, please, in general terms, what you say in paragraphs 131 and following? And you give an example in paragraph 133.
Yes, I give an example of that, and I used the word looting deliberately because it's pure looting. Yes, of course, there are investigations that are taking place. We were also promised that the crime intelligence itself will conduct its own internal investigation. To date, we are aware of about 2 members who are dismissed. I think that they've appealed and so forth based on those findings. Now, What was happening there, and I'm giving an example later, is that we were even calling the subordinates the runners. What will happen is that a chief financial officer based at crime intelligence will be involved in operations. An example of an operation here is that he will handle a source. And it's not acceptable. But because he cannot go and claim money for that particular source, he will use a captain or a colonel or a warrant officer somewhere because he will be a major general. So a poor captain will go, collect money, give it to the CFO. The CFO will then claim that I would have paid a source. And the settlement will then be done on behalf of the captain, not on behalf of the person who claims that they are actually real handlers of that particular person. So we are calling them runners, that these senior managers will then have these other people.
So a senior official would require a subordinate to go and collect money allegedly for the payment of a source.
That's correct, Chairperson.
That money would be given to the senior official who had no authority to deal with sources at all.
That is correct, Chairperson.
And that senior official would then say or claim, perhaps not, that that money had been handed to a source. Correct?
Yes, he will just return and give him something and say that I've given to the person that I've given, so you can go back.
But the person accounting to the system, as it were, the accounting system, would be the runner, the person deputized by the senior official. Is that correct?
That is correct, Chairperson. And during the investigation, what was also surprising is that I think that we'll have an affidavit. I stand to be corrected here by the staff members in my office. But in an instance where a subordinate will tell us that I do not have any proof that the money was given to a source. I don't even know who that source is.
Yes, that's the point I wanted to raise. The subordinate or the runner who is used to collect the money, allegedly to hand over to a source, and is used by the senior officer. That subordinate or runner has never seen, in this example, the source.
Not at all.
Cannot, but nevertheless accounts and says that the money has gone to the source.
Yes, that's what the account will say.
Let me also just make sure I understand it. So you have somebody such as a CFO who, in terms of his authority and job description, is not supposed to have a source.
That's correct, Chair.
And a source here is that right? Or it can be.
I don't know if I'll not be discussing the method here.
Yeah,
but a
okay.
source could be somebody at the taxi
gives
rank.
Information.
Yes, it's somebody at the taxi rank. Yeah, it's not a police official.
Yeah.
It could be somebody at a taxi rank who says
yes,
that
okay.
I saw when this thing was happening.
Yes, it's somebody who gives information required by the organization.
That's correct.
Okay, all right. And there could be different categories, but that's the general.
Yes.
So if I, as CFO, want some cash, maybe from time to time, I could just have somebody that I connect with, a subordinate of mine, who, in terms of the law, is entitled to have a source.
That's correct, Chairperson.
And then I give the money to my subordinate to give to the source, and then I get it in some other way, or no money gets given to the source physically, but the records are written in such a way as if my subordinate gave money to a source.
No, you misunderstood me
Yes.
there, and it's very critical
Yes,
that I
yes.
explain. Now,
Yes.
the CFO instructs the subordinate
Yeah,
to go to accounts department
yeah.
and collect money there.
Oh,
And the reason that he's using there is to say that you know that I have
source.
a responsibility to handle a source.
yes.
So this money that I'm taking from you is for a
It's
source.
for a source, okay.
But he never goes to the source himself.
Oh.
He gives it to the CFO.
To the CFO.
Yes.
Oh, okay. So,
And then the
so-
CFO tells him that, no, don't worry, I'm going to give to the source.
Oh, so suddenly the CFO must give to the source.
Yes.
But,
that is the claim made
yeah.
by him.
But would both of them know? I guess the CFO knows, the subordinate would know what is going on, that this is criminal.
They know, the CFO knows, the subordinate knows.
The subordinate also knows.
Yes, that's why we are calling them runner, because
Yeah.
I think that there was a suggestion by the evidence that they could have been getting some kickbacks,
Yeah.
but we really
Yeah.
do not have
Yes.
that kind, because why would you go there? Because when
Yes.
questions are asked,
Yeah.
they will not be posed to the CFO, they will be posed to
Posed to them.
yourself
Yeah.
as a real handler, as
Yes,
you claimed.
yes. Okay.
And there's an added element that you've just said, but perhaps the public requires a more detailed explanation or a clearer summary, Chair. I'll attempt to do that. The CFO says to a subordinate, you go and fetch money and you tell administration that it's for a source and you give it to me.
That's correct.
And then the CFO says, I'm going to give it to a source. He may or may not do so.
That is what our proposition is.
Right. So he may keep the money.
That's correct.
He may give the money for another illegitimate purpose because the CFO has no mandate or power to deal with monies in this way.
That is correct, Chairperson.
That's why he must use a subordinate who has the power to go and get the money in the first place.
That's correct.
But importantly, also to report that the money has been given to the source when he doesn't know that at all.
That's correct.
But the subordinate also knows that what the CFO is doing is criminal because he knows that it's not part of the CFO's job to be paying sources. Or is there no such, or is that not the position?
Although we do not have concrete evidence to say that they were getting kickbacks, and that's why I'm using this word selectively, of a runner. But he is aware that in terms of the prescripts, that is not allowed.
Yes.
And if he was oblivious to that, he would ask the CFO as to why don't you go straight there. So
Yes.
this is an activity of a person who is fully aware that the CFO cannot handle a source.
Well, I guess the bottom line is the law doesn't allow the CFO to be taking money to a source. Because if the law allowed that, the CFO, if he was acting lawfully, would go to the accounts department himself.
That is correct, Chairperson.
Yes. The reason why he must use the subordinate is because he is not allowed to go there and claim money from the accounts department for purposes of giving to a source.
That is correct, Chairperson.
Yeah.
You give another example in paragraph 134, page 817, but you've dealt with the system that can be used or abused. Paragraph 135, you say there are many other instances which include the misuse of monies from the Secret Service account, misuse of safe houses, and the renting out of personal houses by senior managers as safe houses to crime intelligence at inflated prices. Investigations into these abuses cannot be concluded because there is a refusal to declassify documents. Let's deal with the first issue first. We know from other sources that these this type of misconduct or illegal use of monies and assets has occurred, but was this also part of your investigations, and were these your findings?
These are findings, Chairperson.
On investigations into the detail?
Yes, with the details.
And you've summarized the findings here? Or you've summarized the type of malfeasance that occurred?
That's correct.
Right. Would these issues and reports and findings also be included in your certificates?
That is correct, Chairperson.
Right. You then say something in addition, in paragraph 135, you say investigations into these abuses cannot be concluded because there is a refusal to declassify documents. Before you answer the question that I'd like to put to you, I'd like to put you a preliminary question. Is it clear to all concerned that classification cannot be used to conceal criminality?
That is the general principle, the general rule.
Is it also clear to all concerned in terms of the legislation that classification cannot be used as a reason for not giving you documentation?
That will be my response, but there is a rather to that. That last sentence does not refer to us. It does not refer to the investigations conducted by the Office of the Inspector General of Intelligence. I don't know, I may have, it sounds as if that is the submission, but it's not a submission. When I say investigations cannot be concluded, now I'm referring to criminal investigations, and we've got instances such as those. In our case, they do not have a right to withhold any information,
yes,
whether classified or not.
That's
they
clear.
always give to us. Right. So our investigations in the certificates will be concluded, but the other investigations that follows will be hampered by refusal to declassify.
Right.
So I'm referring to investigations such as those conducted by IPID, for instance, and those maybe conducted by the Hawks. If you will.
We'll come to those in detail in due course. The regulations in terms of security are unfortunately and ironically and quite improperly, Chair, in our submission, themselves secret. So the law or the regulation which says you cannot use classification to conceal criminality is secret. But that principle is widely known, as I understand it.
It is widely known, and I think that it is laughable. In fact, the team have always laughed about it. Maybe I should just explain what happened with the specific one. Now, the SSA wanted to develop a regulation which will sort of put into effect the provision of the missed document. Now they decided that we should have our own document in the regulations, which takes that provision, which says we cannot classify documents to hide malfeasance. But guess what they do, Chairperson? The very same regulation, they classify it as secret.
So it has the consequence, Chair, that any person affected or interested in unlawful classification of documents cannot source the very regulation that deals with the issue.
But the classification of the law, or the classification of such a document can't be legitimate. I mean, if you do that, how do you expect that people will benefit from the principle that you can't use classification to hide criminality?
Well, Chair, the idea that one could classify the law.
I mean, you just have to say it to realize how absurd it is.
There's another dimension to that, Chairperson. I'm just imagining then if it was myself and I contravene the same regulation. And they wanted to ask me questions. Let's maybe I'm an operative and I overclassify. And they said that, no, but you've contravened that. My response will be that once you classify, you say that you apply a principle of need to know. So, which means that I may not have been considered as a person who should be aware of that particular thing. And I can easily say that, but it's classified. I did not have access to it. So you are defeating your own purpose, your own objective, by ensuring that people do not overclassify, because they will say that I'm not aware of that.
Yes, and it goes a lot further than criminality. It talks about administrative abuse as well. That classification cannot be used. We can get the wording. I think you deal with it somewhere in your statement. You deal with it, the expression in the misdocument, but let's deal with it when we get there. In paragraph 136, well, perhaps we should then just clarify what you say in paragraph 135, that these abuses, this criminality, is reported to a law enforcement agency.
Yes, but over and above that, the management, divisional management of crime intelligence, also promised us that they are going to deal with these issues and are going to refer them to law enforcement agencies, because our recommendation would be that here it's a clear case of criminality, so please refer it. We do not want to replace the management of these agencies. We can only flag and point out to where malfeasance, or especially criminality, would have taken place.
It's up to them to take it further in terms of law enforcement, prosecution and the like.
That is correct, Chairperson. And I think that they would have developed an access card for me if I really had to do that. I mean, into the courts. I could be at the magistrate courts and the other courts every day of my life because of the level of malfeasance in those services.
Now, but you say that in paragraph 135, you make the point that these law enforcement agencies, their investigations and prosecutions are hampered by the refusal to declassify documents.
That is correct, Chairperson.
And in paragraph 136, what is the evidence that you give there?
All right.
It's another form of fraud or malfeasance.
Yes, it's another form. And maybe I can use an example of what happened there. So they would have told us that they procured a license. Chairperson, I do not want to, because it will be names of companies normally. But on Advocate Pretoria's laptop, he will have, like for an example, an anti-spyware in that. So normally you will pay a certain license fee. So they bought something along those lines in a region of millions, and the intention of that particular license was to protect the principals within the environment, within the management, so that the gadgets could not be easily intercepted by foreign, agencies and so forth. But now what we found, because I went there personally again, what we found is that, in fact, the license itself or the software was never delivered. And the investigators in my office were actually tipped that it was never delivered and it was about to expire. So normally you will pay it for a period of 12 months. But when we went there, we satisfied ourselves that it was supposed to be still there and we requested that we should be taken there so that we can observe it, and there was a confirmation that it was not available. It was never delivered.
So procurement funds for procurement, are basically stolen.
That's correct. They buy non-existent things.
Which means they pocket the money.
That is the only inference I think that one could
But on the records will say the money was used to buy such and such an equipment or something like that. But the equipment would not be there.
That is correct, Chairperson.
And just to confirm once more, these various investigations in their detail, including your findings and recommendations, would be in the certificates you've spoken about.
That is correct. I confirm that, Chairperson.
Let's move on then to paragraph 137 on page 817. What is a grabber? Grabber, without revealing too much message.
Well, it's a general term that they use, and there is a certain gentleman who's appearing before a court in Centurion who was charged with that, so it is in the public domain.
Okay.
But a grabber is an equipment that can be placed within a particular radius, and it will be able to create a tower. Now, there's scientific issues, but it will create a tower. So, in other words, when I call the chairperson, you will have the other line. So that machinery will be like between myself. So call it eavesdropping, because that particular person does not really prevent my communication to reach you, but they only have a capability of hearing the conversation between myself and the chairperson.
So if the grabber is placed in the required radius of a party conference, and you'll give this evidence now, it would be possible for the person in control of the grabber to hear everything that is spoken over cell phone.
That's correct. Yeah, including, it goes to an extent of emails as well. So let's say digital communication in general.
So all electronic communications would be able to be monitored within the specific required radius of the grabber.
That is correct, Chairperson.
So in paragraph 137, you refer to media reports. Would you, without naming the company and the name of the person who's the director of the company, please, and I'll explain the circumstances there, Chair, in due course, but would you tell the Chair the story of the grabber?
All right.
And its procurement.
Okay. However, we use the names that we would have used. I think it's very important to refresh the chairperson's memory to say that there was this gentleman called, that we call Ivano here.
Ivano.
Yes, who is a director of a company called IBI. So this person is the person who accompanied a group of other people to go and investigate Mr. McBride. He's the same person now, but he is appearing under the other circumstances. Now, just days before the Nasra conference, I received a call from Mr. Mbidwani, Mr. Bongani Mbidwani. He was given notice, I'm aware of that, chairperson. And at that time, he was the advisor to the then Minister of Police, Mr. Fikile Mbalula. And what informs me is that there is an urgent issue that I want to discuss with you, and obviously he will tell me that he's sent by the minister, but I really have to impress upon the commission that the minister never really requested me to attend that particular meeting, but I went. And then when we met at that particular place, he told me that there was a group of backpackers who wanted to influence the conference, the outcome of the conference, the Nasra conference. And
That's
that
a group, I'm sorry, a group of what?
he called them backpackers.
Backpackers.
Yes.
Okay.
Well, they use that concept in criminology and so forth, but it will be like people who will claim to be tourists. For instance, so they are known to have these backpacks, you know, maybe full of cameras and so forth, because they will do that. Yeah. So, but that's how he described that group of people who were said to be coming from a foreign country, and they were, littered around Soweto. So he told me that the biggest challenge that they had is that the then acting divisional commissioner of SABC did not want to procure the grabbers. He said that they were actually in need of grabbers to a tune of 210 million rand. However, because the date was too close, they could settle for one grabber at a tune of 45 million rand. He explained, like, IG, this is how it works, these are the capabilities, so don't be surprised that it is so expensive. An ordinary grabber cost around 7 million rand. But the reason why he called me was to say that the divisional commissioner was scared or didn't want to purchase because I was conducting some investigation with the previous procurement. And I felt so bad. I said, how could they want to use my name? And if something terrible really happened, it will seem as if, I was involved in that. Hence, I promised him that I will go to the divisional commissioner and tell him that, no, don't worry. If there is a threat and so forth, please continue, manage the organization and make decisions. And that's what I did. I left there immediately and I went to see the divisional commissioner. I know I'm taking law, but I think it's important to do this. When I got to where the divisional commissioner was, he was not at his headquarters, he was at the other place. We met, so we will normally meet in a room. So he had prepared a room. We didn't even get to sit down because the divisional commissioner then asked me, are you aware of the company that they want me to procure from? I said, no, he didn't tell me, and he mentions this company, IBI. And I immediately said that, no, but he was not honest with me, hence I'm no longer getting involved in this particular issue. Then I understand why you do not want to procure. And that's where we ended on that day, telling the divisional commissioner that, no, I was coming to permit you or somehow tell you that I will not stand in front of any procurement, but in this instance, I'm no longer getting involved.
Right, so in summary, there was an attempt to procure, and it seems to me that you suggest, at least in your statement or your affidavit, at an exorbitant price, a grabber for use at the NASREC conference of December 2017.
That is correct, Chairperson.
Is it correct that that intended procurement was halted by IPED?
That is correct.
And amongst the reasons, as you say in your statement, was that the company from whom the grabber was to be procured had already been flagged in relation to irregular procurement previously.
That is correct, Chairperson. But we also, as the office, as the OIGI, we are involved in tipping the IPED. In fact, a senior manager from my office was working with a senior manager from IPED because we had information, and I'm calling it information, not evidence, information to say that the rest of the money will be used to buy votes at NASREC.
So not only was the procurement process irregular, not only was the party from whom the grabber would be procured already under investigation for irregular procurement, but you had information that the use to which the grabber would be, the use to which the money would be used either through inflated procurement or otherwise, inflated procurement prices was the information you received was to buy votes at Nazareth.
That is correct, and it sounded probable. That's why we interrupted or intervened, because the grabber original price or average price will be 7 million rand, but here in this case, they want 45 million rand to buy only one grabber.
Right. And during this process, when problems arose about the procurement, influence was sought to be exercised on you to facilitate the transaction. Is that correct?
That is correct, Chairperson. Maybe I should also mention that I stopped somewhere about this procurement, but there was a subsequent meeting again that took place in Sandton.
Well, just tell the chair about that, please.
All right. Now, after withdrawing, telling the divisional commissioner that I will not get involved in this because I did not make those decisions, I then received a WhatsApp message that I'm attaching in the documents that will be coming from Mr. Bob Bidwani, saying that, IG, I had thought that we agreed on a particular position. And my understanding is that that WhatsApp message came as a result of the DIFCOM is Divisional Commissioner, telling Mr. Bidwani that, no, that guy did not, agree, or he didn't want to be involved in this particular process. And then I said that I will settle then for a tripartite meeting, because I spoke to you alone, I went somewhere else, and I got a different story, so let's meet. And yes, of course, subsequently we met here in Sandton. And again, I reiterated that I do not get involved in procurement by any of the services, as long as they procure in accordance with the applicable prescripts, with any other legislation that regulates procurement. And I ended up leaving that particular meeting, and the DIFCOM remained behind with Mr. Bidwani.
Right. Now, should Mr. Bidwani have been involved in procurement at all?
He was involved,
But should he have been involved?
No, he shouldn't have. He said this is a ministerial special advisor. Even the minister for that matter, never really get involved in, that's exactly what they tell us. And in this instance, I have to be very clear that even Minister Mbaluga has never ever discussed this matter with myself. It was the advisor who was pushing for this.
Right. And the relevant crime intelligence unit that would have been responsible for the purchase of this grabber, was it ever consulted? Did you investigate this issue?
I investigated that, and they were never told.
They didn't even know?
They didn't even know that there was a process to try and purchase this particular equipment.
Now you say...
And sorry, Mr. This could be very much important to say that if I'm heading surveillance in crime intelligence, they call me end user. In other words, I'm the one who initiates the process. Go to the procurement people and tell them that I'm in need of these 3 bottles of water. And then they will conduct their own research, source the prices, and then buy. So I'm an end user. I must initiate. It cannot be initiated anywhere else.
Now, you say in paragraph 143 that media reports suggest that the money was in fact intended to be utilized for vote buying during the mentioned ANC conference. I cannot comment on the correctness of these reports, other than to note that the procurement process was stopped when IPID became aware of the irregularities and raised a query. Are those comments an accurate reflection of where you stand in relation to your own knowledge?
It is correct, and that's the reason why I said that information should not be misconstrued for evidence.
Right, so you were relying on media reports, you had a suspicion, those suspicions were corroborated, but you have no knowledge of that fact of the vote buying.
That's correct, Chairperson.
Right. But you say that that matter is under investigation by IPID.
Yes, it was under investigation, and there was also litigation with regard to that particular matter. In fact,
Correct.
yes, there was a finding to say, I mean, a judgment which says that those documents must be declassified.
Now, well, that's the point. The IPID was investigating these series of events. Right?
That's correct.
Were they able to access the relevant documentation?
Not at that stage.
Not at that stage, before the court case.
Before the court case, yes.
And how did this affect their ability to investigate this obvious, well, certainly obvious allegations of criminality?
The investigation could not even take off, as far as I know, because there was an application by police management, including Mr. Mbidwane, to say that IPID cannot have access. And I think that interdict was, issued until there was an appeal or a review as far as that decision was concerned. Yeah.
Now, all these are serious allegations. Are they currently still under investigation?
We know a lot more now. But even at that stage, as the office, we knew more than what IPID knew because we're in possession of these documents.
Right.
And
is your office investigating the matter?
yes, our office also got involved in the investigation of that particular matter. Remember that I always say, Chairperson, that the other agency cannot stop the investigation on our behalf or at our instance because we are reporting to different authorities. So IPID was conducting criminal investigation. We were conducting, if you like, oversight investigation.
And would you have reported your investigations to the various instances in your certificates, or would you do that in the future?
It will be in a certificate, this one, because it's a 2017 matter, so it will be in the 2017-2018.
So all this has been reported to Parliament?
That's correct. Yes, that's correct.
And the response?
No, there wasn't a response as far as that is concerned. But I think that even the ANC members in that committee were really concerned and worried about what I reported to them.
Was this reported to you, this concern?
Yeah, the concern. So it will be during the deliberations, during presentation, when they start commenting and so forth to say that, but this is worrisome, that it is actually happening.
Right, so did you make a presentation on the basis of your certificate to the JSCI in relation to this issue?
That is correct. I did that, Chairperson.
And what, well, I suppose the proceedings are top secret. Is that not correct?
Yeah, they are.
All right. So we'll consider that position and deal with it. But maybe the chair wants to ask a question.
Well, I asked the question, you know what you would have said to the committee. You can't tell us what the committee said, but what you can tell us is whether subsequently there is anything you have observed which indicates that the committee has done something about it.
I don't think I really understand your question, Chairperson.
Okay. I'm trying to deal with the problem that you can't tell us what the committee says. But you can tell us if indications are that something has been done.
Okay.
In terms of what you have observed since then.
The other part then happens in the public domain.
Yeah.
It played itself So I do not have reservations
Yeah.
informing the committee
Yeah.
what happened then
Yeah. Yes.
about this.
Yeah.
I think two issues that I want to mention, Chairperson.
Yeah.
Now, during the time that it was reported, in the public domain, there was an expression by senior ANC officials who are not even in parliament to say that this is worrisome and these monies are used to fuel the factions, yes, in the ANC, and some of them were also worried to say that to what extent can crime intelligence be involved in their internal political
Matters.
event, because that is an internal ANC event. It's not a government event. There is confirmation that officials of crime intelligence were even removed from NASREC, and they were told to go a little bit far because they were causing problems for that particular conference. But now, after the court decision, this issue came to the fore again, and there are two incorrect narratives that have been created about this particular issue. The declassification of the documents revealed two things: that General Sithole never signed the procurement of this grabber of 45 million rand. The second issue that belongs to the declassification is that General Sithole kept on telling the other managers, the management, that you can do this as long as you comply with procurement prescripts. So he kept saying those two things. But the problem is that the narrative that was being built whilst this was still classified was that General Sithole signed the submission and that he could have allowed a deviation, but it never really reached that particular stage. The other issue, which is very important and critical to national security, is that it is in the public domain again, where Minister Tele accused or said that this grab of the 45 million was also could also have been used to intercept the emails of the then deputy president of the ANC. But that event took place way before, we were involved in that investigation, way before this attempted procurement. So those are the issues, the narratives that are incorrect, and they are playing themselves out now in the public domain.
And the correct position, at least the position evidenced by the documents now declassified and public, was at least that General Sithole did not approve.
That's correct, Chairperson.
Right, you deal in paragraph 144, Dr. Dintwe, with a new issue, and that is an issue involving the same company, Ivano's company, and you deal with a different form of corruption or malfeasance in relation to information technology solutions for intelligence collection. Could you tell the Chair briefly about what happened here? You deal with in paragraphs 144 and 145 of your statement.
Yes, so this is the general and similar principle that they procure irregularly, and sometimes goods are not delivered, the problem that I've expressed. But here, let's say that they change the tact, they change the modus operandi. In this instance, they call for quotations. And when we analyze these quotations, there were certain facts which came to the fore. The first one being that the font, the manner, the structure of the quotations was actually similar. The other concern, or what we established, was that one of the companies that provided one of the quotations was not even involved on this. They told us that they are an HR consultancy company, and they said that they've never even sold any equipment of that particular nature.
Sorry, if I could just stop you there. I'm sorry to do this, but I think maybe you and I are out of sync here.
Okay.
I think you're dealing here with paragraphs 146 and 147, the voice encryption system.
Oh, yeah.
If you could go back, please, to paragraph 144, where there was a quotation from the Council for Scientific and Industrial Research, CSIR, for an amount of 7 million rand for a particular software solution. Tell the chair about that incident, please, and then we'll get on to the voice encryption system.
All right. Now,
so at the top of page 820.
yes, I see that. Look, CSIR is a government entity. It's something along those lines, and the researchers there will develop some of the solutions for state information technology agency, SETA, or for other government departments. So in this instance, they had offered the crime intelligence that we could develop this kind of IT solution for yourselves, and it was going to be at around 7 million rand. But now, that offer was then ignored, and SABC then called for the other quotation over and above what CSIR would have offered them.
For 33 million rand.
For 33 million rand now, this time around.
But to make matters worse, you then did an investigation to find out whether this IT solution had ever been actually installed.
That is correct, Chairperson. I did that, and I visited personally with members of my office, visited.
And what did you discover?
We discovered that it was never delivered to crime intelligence.
So quotations go out for an IT solution. CSIR say we'll provide it for 7 million rand.
That's correct, Chairperson.
This particular company says we'll give it to you for 33 million rand.
That is correct,
It
Chairperson.
is procured from this company, in inverted commas.
It is procured, in inverted commas, monies are paid.
Monies are paid, but nothing is installed on your finding.
That is correct, Chairperson.
And you relate that, your personal visit and your personal investigations in paragraph 145. And you say you were informed that the original product no longer existed and had since been replaced. But you couldn't be shown the replacement either, is that correct?
I could not be shown a replacement as well, Chairperson.
Right.
So again, it's just pure theft.
Pure theft.
Yeah.
So your conclusion was in paragraph 145 that the amount of 33 million rand was fraudulently paid from crime intelligence to this company for a non-existent product. And you then say IPID has since been investigating this matter, but has to date again not succeeded in securing pertinent classified documents relevant to its investigation.
That is correct, Chairperson.
What would be secret about these procurement documents?
I'm always argue that you cannot overclassify this issue. This is a pure procurement issue. There's nothing national security about it. There is nothing intelligence about it. It's like procuring a car.
And then in paragraphs 146 and 147 on page 820 and following, you deal with the voice encryption system procurement process. What happened there, just briefly? You talk about cover quoting.
Yes, but it's the same company now. This company gets involved in all this kind of procurement, which are actually surprising and irregular in certain instances, not even getting delivery. But in this instance, that system but on that paragraph, I'm talking about flouting of the procurement regulations again.
Which was also existent, you say, in relation to the previous issue that you've discussed, the software solution. You said that prescripts weren't followed.
That is correct, Chairperson.
Here, prescripts were also not followed in relation to the voice encryption system, where it was procured for about 23 million rand.
That is correct, Chairperson.
And you say that all manner of procurement requirements were flouted.
I submit that, Chairperson.
Yes, you say the system was not, however, procured for any crime intelligence section responsible for any counterintelligence function. Is that correct?
Yes, that's correct, yes.
Right. But what
so in the instance where I said, Chairperson, that an end user will be somebody who's responsible for that particular thing. So if you say that it's a voice encryption, if you say it's a grabber, we are looking at somebody at surveillance, and all those issues. But the end user will be somebody somewhere.
The cost of this procurement, you say in paragraph 146, was 23 million rand.
That's correct, Chairperson.
However, you investigated the matter and you saw competing quotes, one for 58 million rand. Were those genuine competing quotes?
They were not genuine, and as I say that paragraph, that we picked up some of the other things. For an example, in one of those, there was no VAT number, a VAT number. And it was also apparent that the latter two quotations were for purposes of creating fictitious competition, also referred to as cover quoting, in contravention of the applicable Treasury regulations.
And those were your findings in investigating the facts?
Those were my findings because the name of the director of Company B was also the director of Company C.
Really? All right, so a related company issues a quote for 58 million rand, and I understand what you mean by cover quoting. It makes the quote for 23 million rand look reasonable.
That's correct,
Is that the point you make?
Yes, yes.
Chair, I must place on record that we have a response from this company. The director is Ivana. But what they say in this response is, we're giving you this information. We don't know whether it's classified or not. That's your problem, they say to us. So as a precaution, we've had to consult with the Director General of the SSA, the Acting Director General, to first see whether we can deal with the whole or the part, and if so, how we can deal with it. So I'm not in a position to put that now. We must go through the process first, and then we will put it up to you. But we might just put it up to you anyway, under the rubric that it's for your eyes only.
Yeah, well, that's fine.
Can we move on then on page 871 to the failure of oversight over the intelligence services? We've dealt with this piecemeal in several parts of your affidavit to date, but if you could just summarize what you say in paragraphs 148 to 150, please. And you can do it in summary form because we've dealt with these issues.
Yes, and I'm admitting on paragraph 148 that I'm not attributing that failure only to the Joint Standing Committee on Intelligence. I'm saying that we have failed also as the OIGI. And I think that I would have provided reasons, what I think were the reasons behind that. Right. Because we were weakened and all those other things. But the failure there of oversight over this organization is also attributable to us as the office.
So, but in relation to that, you've given evidence to the chair about your independence or lack of independence, the structural and organizational challenges you face as the office of the OGI. Its capacitation and funding, we've dealt with that evidence, it's all there. You ask the question in page 871, para 148, you say the chairperson of the commission may reasonably ask how weaponization and fraud and corruption in the intelligence services was permitted to continue in the face of the oversight responsibilities which should have been exercised by the OIGI, that's your office, and what the reasons for the failure of such oversight was in the circumstances. So you're dealing here with a finger that might be pointed at your office.
That's correct, Chairperson.
You've dealt with issues in relation to this earlier in your statement last time you appeared before the chair. But would the same comments that you make now apply to the JSCI? The JSCI is not unrelated in this series of events.
It is related, and I think that's where previously I said to the chairperson that no one within this fraternity should come to you and mislead you that we are not aware of this. Because on paragraph 149, I'm dealing with the certificates, and I'm also referring to what I would have sent, and I think that I'm also attaching the letters that would accompany those certificates to the Joint Standing Committee on Intelligence.
You say in paragraph 149, if I may just read it for the sake of time, the certificates that have been produced and presented to the heads of the intelligence services, the ministers of the three departments, and the JSCI over a period of time reflect the many findings of wrongdoing by the intelligence services made by my office. Monies have been stolen from the intelligence services, and in certain instances these monies were used to fund parallel intelligence capacities and to achieve political ends and or to fight factional battles. These certificates of different intelligence services that were issued during my tenure indicate how the resources of the intelligence services were misused, stolen, and squandered. These certificates are annexed. Well, they're in the documentation that you will provide to the chair in due course, hopefully sooner rather than later. You list in paragraph 149.1, 149.2, and 149.3, you list and identify the certificates for the years 2016, 2017, 2017, 2018, 2019, for the three intelligence structures, that's defense intelligence, crime intelligence, and the state security agency.
I confirm that, Chairperson.
Is the position that, I'm just quickly having a look at those paragraphs, is the position that in regard to each service that falls under your jurisdiction, you have provided certificates for the same period in terms of years, financial years?
That's correct, Chairperson.
Okay.
In paragraph 1,
well, maybe I may be taking you back, Dr. Dintwe, but you mentioned under the failure of oversight over the intelligence services that you include your own office, that it also failed. And then you said you could give reasons you were weakened and so on. It may be that you dealt with it earlier on, but I've forgotten. Can you just tell me this is why the reasons why you say your office failed?
It is because, Chairperson, I mean, if you get to an office and you get appointed, there is an expectation that you should come up with a turnaround strategy, and without really looking at any reasons which justify that, I'm glad to say that maybe we could even have pushed more than this, And I know the attitude of the chairperson. I've heard you saying, telling other people, we will normally say that.
Yeah.
But what did you do with the little that you had? So I shouldn't come here and say that we knelt down, we really got broken down. To me, I see that as a failure of the OIGI.
Okay. No, I'm glad you say that, because, you know, with these problems that the Commission is looking at, which have faced the country, we won't solve them unless people who are leaders are prepared to look at themselves, look at their own roles and say, I know, I accept that from my side, I didn't do enough here. And going forward, this is what I am committed to doing, to make sure that yesterday or tomorrow is not the same as yesterday. You know, if we are not prepared to do that, and if leaders are not prepared to do that, if people who are in positions are not prepared to do that, there is not going to be a change. So I'm always glad when a leader, somebody in charge, doesn't just look at what others have done or have done wrong, done enough on my side, and what can I do differently going forward. So I'm happy that you have said that.
And then there is an example which further elucidates that, Chairperson, that, for instance, over these 4 years, I've struggled to get information, when in fact the Oversight Act criminalizes a refusal by any person in these intelligence services. And I always, wanted to regard that as a last resort. So that is an example of a lapse on our side. And because it doesn't need money, it needs me to cross the road to the nearest police station and open a case, and not wait, not write 4 letters before I can get a single information. So we should not be myopic about the challenges facing the office. We could have done more.
No, thank you.
In fact, have you sought to secure your powers through court intervention?
I've done with the litigation that I would have referred to earlier.
In paragraph 151 on page 822, Dr. Dintwe, you deal with the failure to implement the recommendations of the OIGI. You've dealt with this issue in questions, in answers to questions to the chair. You say at the bottom of paragraph 151, recommendations made and reports produced by the OIGI are largely ignored by the Ministry and the Director Generals of the Intelligence Services. Would that comment apply equally to the JSCI?
That is correct, Chairperson.
And then
there is this legal issue that I think that maybe during the arguments, the closing arguments, maybe the legal team will deal with it. Because if a recommendation is developed and sent to the accounting officer for implementation, can we really bemoan the failure of the implementation and place it at the door of the legislature? I think that distinction should be made. I think that the Joint Standing Committee on Intelligence should only hold the DGs accountable as to the extent that they fail to implement. Because these other issues are administrative decisions and so forth, which are a sole purview or province of the Director Generals. I don't know if that argument is raised, whether it will be acceptable, but I do not want to venture into that myself.
Yeah, no, that's fine. I mean, the one has got to look at what each body or functionary is required to do by law, and did they do what they are required to do by law, or what they were empowered to do but didn't do. So you look at the committee and say, What is their role? What were they empowered to do? What were they obliged to do? What is it that they did? And what is it that they could have done? And you look at the DGs as well. If they should have pursued certain issues with DGs, and they didn't, then do they have valid reasons for not pursuing those issues? Those are the types of questions that one looks at.
So perhaps my question was put into general term. As I understand what you're saying, as the Chair has now pointed out, is that many of your recommendations and reports would be directed specifically at functional officers, for example, the Ministry and the Director Generals of Intelligence Services. It would be their duty to consider your reports and recommendations and, where appropriate, to implement.
That is correct, Chairperson. I think that's what, not I think, that's what I'm saying, to say that majority of the recommendations will go to the accounting officers for implementation.
Yes. But to the extent that they are not implemented, an oversight body such as yourself and the JSCI would then come into play and be accountable for the failure to exercise oversight over the non-implementation of your recommendations.
That is correct, and I think that also in the spirit of legislation, you remember the superintendent's role of the ministers as well. So in any event, if a decision is done, I've recommended to the DG, the minister is aware of that recommendation, I think that her role then should have been that of a superintendent. So she has more powers to ask the DG, why aren't you implementing this?
And then in paragraph 153, you say it is my submission that it is necessary to provide appropriate enforcement mechanisms to the OIGI to ensure that its recommendations are implemented and that a failure to do so should be visited with serious penalty.
Yeah, that's my
Your
submission.
recommendation. The Chair will have to think about that further. Chair, it's 1 o'clock.
I see it is 1 o'clock. Do you have an idea how much more time you need? Because if, for example, you were to be done in 30 minutes, maybe we could delay taking lunch and then take lunch after you are finished. But if it's going to be longer, then maybe we could take lunch immediately.
I'd be at least another hour, and I will try my best to finish within that.
Okay, no, that's fine. Let's take the lunch adjournment then. We will resume it at 2.
Okay, and I have communicated this to the next
no, that's
person.
fine. So for them, probably 3 o'clock would be, they could be here. Okay, we'll take the lunch adjournment. We adjourn.